Admit it's about the most impressive sight anywhere. When I lie here looking up at Zarum, I know I've just got to get there someday. I wonder what the people who are allowed to live there are like. My brother tried to build a kind of balloon to fly to Zarum, and they trashed him as punishment. Know what? I really want to make a pile of money. I'll be allowed up then. I could go legally. Laugh all you like. What's so funny?
You're much more fun to watch than that old satellite.
Well, that old satellite's beautiful, compared with this. Of course, that's not surprising, considering Zarum's been dumping its garbage on us for as long as anyone can remember. They keep it clean up there by dropping their waste on us. That's how the Earth got to be the way it is.
Oh, is that why it's like this?
Antonin Scalia, aka Nino, a legend to some, while others have described him as a flesh-toned cinch sack. I'm not here to give you a biography of Scalia. Does this look like a fucking biography channel? What I will say is this though, Scalia was a virtuous man, perhaps the greatest American appellate judge to ever live. Antonin Scalia completely transcended the role of a judge that's appointed through a partisan political process. Part 1. Paladin Scalia. Scalia's no culture warrior. Instead, he saw his destiny was to be that of an intellectual leader. No lawyer was as much of a smarty pants. He was Aristotle reincarnated as a judge, the King Arthur of conservatives. A true fan of this channel would know who this guy is here. Frederick No Bullshit Nietzsche, the man who predicted the Great Suck. When everyone stops believing in religion, everything starts to suck. In a vacuum of bullshit, any soft-brained grift can gain influence and power. Nietzsche's great hope was that an overman would rise. An overman who could create a new moral order. Instead of an overman, though, we got a wet and slippery turd sandwich. What we needed was a great moral leader. What we got were garbage journalists, worthless college professors, and god-awful judges. The cathedral. We didn't want these people. Certainly they weren't necessary. We deserved better. Overman? Yeah, right. More like Overwatch. Fuck Overwatch. Antonin Scalia's no overman either. Instead, he's better seen as a sort of paladin or inquisitor. He's developed a keen smell for bullshit. This hound-like ability has led him to the revelation that everything stinks. There are false sources of moral and legal authority all over the place. It's his constitutional and moral duty to dispatch these unholy entities. In other words, he's a slayer of fake overmen. A single Scalia dissenting opinion reflects more thought and intellectual ability than the entire career of Stephen Colbert. There's a good reason Colbert and John Oliver have never been in the same room as Scalia. They would have started burning alive in his presence. Scalia's importance cannot be emphasized enough. He was instrumental in establishing the Federalist Society. The Federalist Society has guided Republicans in appointing thousands of conservative judges. This includes Supreme Court justices. That makes Scalia perhaps the most consequential conservative thinker of our time. Part 2. The prehistory of law in the United States. Okay, enough of the esoteric weird shit. Antonin Scalia was a practical guy. He made decisions using a legal philosophy which wasn't complicated or strange. No Nietzsche bullshit or overman or anything like that. So let's learn some shit. First, we need a history lesson though. If we want to understand our Constitution, we need to know what it replaced. Of course, what it replaced was the British government, the King of England. Everyone knows about that asshole. However, we tend to forget he was only part of the British government. We're talking about a two-headed dragon here. The other head of that dragon was the county courts. Yep. Shitty little courts run by judges often in bumfuck nowhere locations. They dealt with all of the bullshit that the king didn't have time for, which of course was a majority of the bullshit. While the king was concerned with things like imperializing Africa, trying to fuck with Gandhi, and beheading wives, the courts did all of the boring shit. tedious, busy work like creating the laws of the British Empire. This process of law creation was known as the common law. It involved resolving disputes based on customs common to Anglo-Saxon or German cultural tradition. Sometimes these county court judges would have to resolve complicated disputes. The judges might have felt like they needed to do a lot of research before reaching a decision. Often with these, judges would write down an explanation of their decision. Maybe they thought it would help judges in the future. More likely they were just vain narcissists though. Anyways, lawyers would sometimes use these past decisions in arguments. The courts would sometimes follow them and sometimes make exceptions. Of course, there were also some times where it got, well, fucking complicated. Harvard Law School was the first school to pioneer a method of legal education that compiled these written judicial decisions into things called case books. Legal education became the research of these past written decisions by judges. Part 3. Scalia's philosophy. Prior to its independence, the United States had laws created by judges in the British county courts. If our founding fathers wanted judges to write the law, it could have adopted this previous system. However, as Scalia points out, the founding fathers thought that this way of doing things was shit. The founders wanted a legal system where laws were written by an independent legislative body. This was modeled after something like what had existed in the Roman Republic. We all know that Rome is so much cooler than the British Empire. So Scalia points out, judges aren't meant to make rules or create policies. They're not a source of moral authority. According to the Constitution, their role is to interpret the laws that are written by the legislature. That's it. Fucking simple. There was a problem though. For the last 2 decades, the Supreme Court has been legislating morality and issuing legal opinions based off totally arbitrary bullshit. The first demon that Scalia sought to slay was legislative history. It had become common for lawyers in these disputes to present prior drafts of these laws. The court would use these prior drafts to try and determine the intent of the legislature. This included shitty prior versions of the laws that weren't passed. It also included comments made by stupid, sleepy congressmen during arguments over whether to pass the law. Scalia always believed that this was nothing more than bullshit. The reason the lawyers and courts were researching this was to provide more arguments to the court. The court wanted to be in a position where it could make any decision it wanted to. This is just like how the courts used to operate under the common law. That made it more valuable for the courts to have access to more information to base their decision off of. To avoid this problem, Scalia created the doctrine of textualism. Legislative intent is irrelevant. All that matters is the end text of the law. If the legislature fucked up, it's on them. Scalia used the case of the Church of the Holy Trinity versus America to illustrate his point. Congress passed a law to prevent anyone from paying a foreigner to immigrate to America. That's because, just like today, nobody wanted these people here. The law included exceptions for certain workers who could still be paid to immigrate. This list included actors, certain academic professors, adult theater squeegee men. The Church of the Holy Trinity had paid some jackass to come from Europe to the US to work as a pastor. However, a pastor was not one of the workers listed on this list of exceptions. The Supreme Court nonetheless made a couple of observations. Number 1. The people serving in Congress were religious. Number 2. No one serving in Congress gave 2 shits about the separation of church and state. Number 3. Therefore, Congress would have intended this additional exception to exist. You see, they just forgot to put it in there. Scalia says that this is bullshit. The Supreme Court doesn't get to guess what Congress would have wanted. They have to base the decisions off the actual text. That's why it's called textualism. Duh, fucking morons. But sometimes this shit is confusing. What the fuck does this mean? If I'm a judge, how am I supposed to interpret this? Don't worry, Scalia has another ism for you. Thankfully, it's not voluntarism. Okay, most of you already know that I'm talking about originalism. Okay, so we don't know what the fuck that this law says. To figure it out, we need to determine what these words meant at the time the law was passed. Again, the key is the words in the statute itself. That's because originalism is meant to complement, not replace, textualism. Now, sometimes people call out Scalia as being some sort of hypocrite. They'll point to a time where he strictly followed the text of a law. Then they'll contrast that with the time that Scalia considered a wider meaning for the word. This isn't hypocrisy, though. Scalia isn't an autistic moron. He understands that sometimes the text in statutes is deliberately meant to be vague or broad. An example that he considers is the First Amendment protection of free speech. Scalia says it would be wrong to interpret the First Amendment as only protecting spoken words. The First Amendment ought to also limit the government when censoring, for example, written correspondence. This is because the word speech was not meant by the founders to be taken literally. Only a dumbass would interpret it that way. Of course, all of this walks a line. It may not always be clear whether a word is meant to be taken literally or broadly. Scalia is not some fucking miracle worker. While judges shouldn't be policymakers, they can't be made into literal machines. Some guesswork is still going to be required. Legislative history was already a pretty bad problem. However, there was a far more insidious and endemic problem that Scalia could see when he was appointed. It was a legal philosophy that had become popular in the 60s and 70s. A legal philosophy that was based off complete bullshit. I'm talking about the philosophy of the living Constitution. This liberal interpretation was based on the idea that the US Constitution was meant to be changed over time. It was meant to be adapted to current cultural and societal expectations. On a rational or empirical level, there was no support for this. Nothing in the Constitution says it's supposed to be some living thing like a dolphin of liberty. The other issue is nothing gives judges the authority to be some sort of arbiter of societal or cultural norms. When judges pretend to have this authority, they step into the role of the British common law judges. We didn't want effeminate men in wigs writing our laws. We wanted badass Roman senators to do it instead. According to Scalia, this gets even worse. When judges ignore the text of laws and impose their own beliefs, they bypass the democratic legislature. However, when judges interpret the Constitution itself however they want, it results in an undemocratic abomination. The judge has not only taken on a role that's supposed to be reserved to a democratically accountable legislature, he's now taken away the legislature's authority to ever change or disagree with the decision he made. Democracy itself starts to get fucked up. Number 4, death penalty and crime. Now we get to cover my favorite part of the Constitution, the death penalty. Scalia believed the death penalty was an important part of the Constitution. You'd have to be an ignorant buffoon to believe the death penalty is unconstitutional. Oh no, the opposite is true. Do you disagree? Well, when was the last time you actually read the fucking thing? Let's take a look at the Fifth Amendment. It starts out saying, no one shall be put on trial for a capital crime without having been indicted by a grand jury. Capital crime means a death penalty crime. It goes on further and says that nobody shall be deprived of life, liberty, or property without due process. Notice life was one of the things the government could take away, so long as it did so through due process. So yeah, our Constitution is actually pretty badass. Despite being clearly endorsed by the Constitution, many judges disagreed with this. Judges identifying themselves as moralist, working for the institution of the cathedral, have limited the death penalty's use over time. They've done this using the handy-dandy tool of the Eighth Amendment's prohibition on cruel and unusual punishment. Cruel and unusual punishment was supposed to cover things like shoving a pineapple up a man's ass. It should have never been applied to the death penalty. So how did the cathedral do it? They tied death penalty practices to whether most states followed them. So let's say that 35 states prohibited the death penalty for child rapists. In the remaining 15 states, chomos get the chair. Federal judges would strike down the death penalty in this situation for being cruel and unusual because most states don't do it. Over time, these decisions have greatly limited the scope of the death penalty. Scalia always opposed these decisions. He'd usually lose though and have to author a dissenting opinion. Scalia believed judges should not be changing the Constitution based off of popular opinion. That would be, according to him, the very thing that we're trying to avoid by having a constitution in the first place. This isn't the only problem Scalia has identified with attempts to limit the death penalty, though. The Eighth Amendment, like all of the Bill of Rights, originally applied only to the federal government. So just apply it to the states through the Due Process Clause of the 14th Amendment then. That's what we do with all the other Bill of Rights. Well, how can we possibly conclude that the death penalty violates the Due Process Clause of the 14th Amendment? The Fifth Amendment explicitly says it doesn't violate due process. You could drive fucking semi-trucks through a contradiction this big. All of the legal decisions that have limited the scope of the death penalty are therefore contradicted by the Constitution itself. Every limitation on the death penalty imposed by the federal courts is unconstitutional and invalid. Unless, of course, those limitations are purely procedural in nature. We're going to skip the Fourth Amendment because I already talked about it in another video. There is one issue, though, that I wanted to talk about where Scalia almost always sided with criminals. The Sixth Amendment gives criminal defendants the right to confront witnesses against them. This typically means they get to cross-examine the person under oath in front of a jury. However, this has proved problematic in certain cases. Chomo cases. Little kids who were raped can often be traumatized. I think most little kids would be uncomfortable testifying in a courtroom full of adults. It's even worse if they're a victim of rape and their rapist is in the courtroom staring at them. Sometimes these child rapists will choose to represent themselves for the distinct purpose of making it more intimidating on the child witness. If they can discourage the child victim witness from testifying, then they'll be acquitted. Courts have tried to get creative with things like, for example, having a child witness testify where the defendant can see the child, but the child can't see the defendant. Scalia consistently found that these efforts were unconstitutional. The text of the Constitution is clear. The defendant gets to confront the witnesses. Common sense says this means he gets to be there and look the witness in the eyes. Trying to make a workaround to this is altering the Constitution, which again, judges aren't entitled to do. Legally, I agree with Scalia. The text is clear. The Founding Fathers could have made an exception for minor victims, but they didn't. I do find all of this to be a bit unethical, though. A virtuous justice system would not let a child rapist intimidate his victim in this manner. I personally would support a constitutional amendment that created an exception for this situation. Number 5. Abortion and sexuality. When we start talking about sexuality and abortion, we leave the realm of law entirely. We're now talking about mythology. What we're talking about is a cascading series of court decisions finding secret hidden rights that supposedly exist in the Constitution. Yet none of this bullshit is actually in there. Believe me, I've checked. Scalia's position in an abortion case was always clear. There is no individual right to an abortion in the Constitution. Roe versus Wade was nothing but bullshit that should be disregarded entirely. It makes no sense to apply stare decisis to a law obviously based on bullshit. All of these hidden rights were obvious judge-created additions to the Constitution. Given their interpretation as constitutional rights, they were incredibly undemocratic and in violation of the Constitution. I respect Antonin Scalia's position on this a lot more than other conservatives on the court like Judge Roberts. Any conservative judge that takes any other position on this issue, in my opinion, has no principles. They put the cathedral's interest above that of the country. Roe v. Wade is a myth with no foundation in reality. The Constitution doesn't mention abortion, and it never will. Likewise, Scalia also condemned derivative rights to engage in butt sex and gay marriage, all based off this same bullshit. Dissenting in the case of Lawrence versus Texas, Scalia points out how little sense the majority decision makes. So we're supposed to believe that based off this right to an abortion that's hidden in the Constitution, we derive this additional right to do it in the back door. The court then applies rational basis scrutiny. But if heading down the Hershey Highway is a constitutional right, it should get strict scrutiny, right? You wouldn't give rational basis scrutiny to a fundamental right. Not unless you were doing something like trying to bullshit people. So the court then finds no rational basis for states to prosecute people for butt sex. However, Scalia points out that this is also wrong. The state has a rational basis to enforce sexuality norms that lead to stable reproductive families. This is the same reason that states make bigamy, incest, and polygamy illegal. If there's no rational basis to ban booty plundering, how is it that we're able to ban these other things? In the decision finding a fundamental right to gay marriage, Scalia's dissent goes further. He points out that any semblance of democracy in the United States has been entirely abandoned. This line of cases could be used to push literally anything on the general population. Pedophilia, polygamy, car fucking, who knows? Sure enough, after Scalia's death, the gay marriage case was used to justify the right to be transgendered. Now don't get me wrong, this set of myths serves an important role in our society. It's a method for the elite manager class to force feed unpopular ideas to the general population. Ideas that wouldn't be enacted democratically in a million years. Number 6. Federalism and the division of powers. We've already established that Scalia hated it when judges made law. I'm also sure Scalia would have hated Fallout 76. If you're an asshole, stop trying to be a vagina. It's just not what you're designed for. For example, Judge Scalia believed the U.S. Sentencing Commission was unconstitutional. Congress had taken a clearly judicial power and gave it to a bunch of moron bureaucrats in D.C. I can't underemphasize how dumb and shitty the U.S. Sentencing Commission is. If you can tolerate reading tedious bullshit, this Yale study is a good breakdown about why these guys are completely worthless. Scalia also believed that the courts had no right to get involved in military affairs. In a dissenting opinion, Scalia wrote that judges have no power to consider habeas corpus petitions filed by prisoners of war.
The man was lining us up for a VC mortar crew. That's true. There's still such a thing as due process. Out here, due process is a bullet.
What about states' rights? Well, Scalia tended to side with the states. The states can do whatever the fuck they want so long as they don't violate anyone's rights. The federal government, on the other hand, is more like a bitch on a leash. It can only do the things that the Constitution allows it to do. This is called enumerated powers. For example, Congress passed a law called VAWA, not to be confused with WAWA. This act, known as the Violence Against Women Act, made it a federal crime to beat your wife. It was sponsored by none other than this guy, Bunker Biden, a well-known lover of women. If you believe that this act was struck down for being sexist and unequal, you'd be wrong. Nope, Scalia joined the majority opinion, striking down VAWA for being outside the Fed's enumerated powers. You see, nowhere in the Constitution does it talk about domestic violence. The government tried to defend the act by arguing it was implied by the power of Congress to regulate interstate commerce. Here's a question for you. How does punching your wife in the face affect the price of tea in Texas? What a crock of shit was that argument. Now I'm sure a lot of dipshits are lining up, getting ready to call Scalia a hypocrite on this. You see, he ruled in favor of the feds in the case Gonzalez vs. Reich. He had the audacity to defend the power of Congress to ban marijuana. Not marijuana. I base my whole identity on marijuana. It's the most important political issue. Why don't you put down the bong and act like a man for a second? Scalia was a principled conservative justice, not some minarchist activist judge. It's not hypocritical for Scalia to find something is within the Fed's enumerated powers. This is the case so long as he can point to something in the Constitution that says it is. We know that the Constitution says that Congress can regulate interstate commerce. Therefore, it would be entirely unreasonable to believe that Congress doesn't have the power to decide what shit can and cannot be sold in interstate commerce. That's always been a core function of a national government. Number 7, the Second Amendment.
Hey man, are you sure you got enough?
Yeah, fucking shooting shit with guns. I'm gonna keep this portion brief. I don't think the Second Amendment is really all that interesting. Scalia was the first justice to author an opinion finding that the Second Amendment protects an individual right to bear arms. This was applied directly to the federal government. It was also applied to the states through the 14th Amendment. As an aside, my opinion of the 14th Amendment is that it's kind of bullshit. It's not clear from its text that the federal courts can use it to apply the Bill of Rights to the states. The problem is that the text of the 14th Amendment is a bunch of vague bullshit. It doesn't explain how it's supposed to be applied by the courts. The courts also couldn't just ignore it or pretend like it didn't exist. So the courts kind of made up this whole sort of process where you could apply rights in the Bill of Rights to the states. You'd think Scalia would disapprove of this because it's essentially a judge making the law. However, the 14th Amendment kind of forced them to do that. There isn't really any alternative process that could have been followed that would have been any less arbitrary. So Scalia just accepted the previous decisions regarding the 14th Amendment. Once that's out of the way, an individual right to bear arms becomes common sense. Only a smooth brain would find that all of the other Bill of Rights apply to the states, but not the Second Amendment. So next time you get the let out, give some thanks to Scalia. Anyways, that's all I have for you right now. Obviously, I couldn't cover every single thing that Scalia has done or written about while he was on the Supreme Court. Antonin Scalia, I believe, authored more judicial opinions than any other judge who's ever served on the court. That's just how hardworking and heartfelt he was about the law. Anyways, if you enjoyed this video and you're not already subscribed to my YouTube channel, please support small YouTube channels like mine by subscribing. Thanks.